Harry's our speaker, so let's give him a really warm welcome.
Thank you. So I'll blow my own horn, do my own introduction. I'm a solo practitioner, been practicing since before a lot of you were born. 1971 I was sworn in, and practiced law for 20 years, and then I had an opportunity, became friends with the founder of now known as Flagstar Bank, who gave me an opportunity to open my own title insurance agency. So in 1987, in Bingham Farms and Telegraph Road, I ran Fidelity Title Company for 20 years and didn't practice the liquor law. And then in '06, and things started happening with the economy and underwriters were getting rid of agents, I found myself back in the practice of law, and I've been practicing full steam. I was just in Oakland County Circuit Court this morning, as a matter of fact. So I'm located in Farmington Hills. I have business cards for you, but my contact information you'll find on page 3 of the seller's disclosure statement bullet points. So what I want to do is I want to go through these bullet points with you. I try to keep it as not so technical and just kind of hone in on the important aspects of the Seller's Disclosure Act of 1993. And then I had a lawsuit in 2017 where I represented a homeowner who, after she took possession of the home, and several months later, actually, she took possession from when she closed, she took a shower and had her laundry going, and when she went downstairs to check her laundry, all this fecal matter and water was coming up out of the basement. So she had me sue the person who sold the company that sold her the house. That was the proverbial wholesaler, flipper. You know, he did make some cosmetic changes and whatnot. So you'll see in the next packet, and I want to give it to you now because I want you, we're going to kind of take a vote as to what happened with my lawsuit, and there's a 12-page opinion. Did I win or did I lose? And so we're going to get to that part 2. So part 1, let's take a look at the, I like this podium. Attorneys like podiums. So let's take a look at the Seller's Disclosure Act highlights. Now this is directed to, are there any brokers or salespersons in the audience? Okay, quite a few. All right, well this will help you out as well. You might find some surprises. And then of course I presume this gentleman owns 12 homes, so I believe you guys have a basic knowledge and have signed. How many of you signed a seller's disclosure statement? Let me ask you that. Okay, we got quite a few. Okay, all right. So since 1993, all Michigan residential sales are subject to this act known as the Seller's Disclosure Act. All sellers of residential properties are defined as 4 or fewer dwelling units must deliver to the prospective buyer prior to, I don't need these glasses, prior to execution of the sales agreement, the statutory form, the Seller's Disclosure Statement, which I will be giving you in your next packet. The Seller's Disclosure Act applies to sales, exchanges, land contracts, options, leases. I wasn't even aware of some of this myself. That include options or tenant improvements and co-op sales. It does not apply to a number of exempt transactions, including sales by a licensed builder of newly constructed residential property. So they're exempt from filling out the Seller's Disclosure Statement. Some people think, well, I never lived there, so I don't have to fill it out. And that's not true, and we'll get into that a little later. You're obligated to fill it out. Now, if you don't know something, I highly recommend you check off unknown, which when we get into my case study, that's where the guy made a mistake. He wrote in there, never lived in the property, but then he went to the trouble of checking off all the boxes and checked off that the plumbing system was in good working order. Thus my lawsuit. Had he not done that, or just checked unknown, I never would have filed a lawsuit. But that was a misrepresentation. We're going to get into that. Pardon me?
I got a quick question, or maybe you're going to answer this.
Yeah, can you save the questions for the end? I want to bust through this.
You might answer it anyway.
I'm sure I'll cover it. Now the form itself contains specific representations as to water in the basement, which is the story we're going to get into, my personal case study. Roof leaks, I had one of those. Septic tanks, drain fields, city water and sewer systems, well and pump, settling, flooding, drainage, sanitary and grade problems, infestation by wood-destroying insects, underground storage tanks, specified on-premises environmental hazards, and neighborhood environmental issues. Now, each disclosure must be made in good faith. The sole and exclusive buyer remedy under this Seller's Disclosure Act is to terminate the purchase agreement. That's your only remedy. If they lied on the seller's, let's not talk about the lying. If they said that, the roof it leaks and needs well, you can get out. You don't want to. He doesn't want to spend, and you don't want to spend the money to repair the roof. You can get out of that purchase agreement because he disclosed he's got a leaky roof, and you don't want to buy a house with a leaky roof. So that's what it's meant by that. There are no post-closing Seller Disclosure Act remedies. Only lawsuits for fraud, deceit, and misrepresentation at common law, which you're going to see my lawsuit in a few minutes, and possibly a breach of contract when the purchase agreement includes warranties as to conditions that prove to be inaccurate. The form requires disclosure of any, quote, structural, mechanical, appliance system changes. So yes, the form, if something happens from the time you first fill out the form and you haven't closed yet, you are obligated to amend the seller's disclosure statement in these areas. Sellers are not liable for errors or omissions, quote, that are not within their personal knowledge, close quote. Remember that. And there is no duty to disclose information, quote, that could be obtained only through inspection or observation of inaccessible portions of real estate, or could be discovered only by a person with expertise in science or trade to be in the knowledge of the transferor. So generally, the buyer bears the risk of loss under, we're all familiar with the as-is clause in the contract, unless the seller fails to disclose concealed defects known to them. So you'll see my lawsuit is entitled Complaint for Failure to Disclose Latent Defects. Sellers have a duty to disclose to the buyer any concealed conditions known to them that involve an unreasonable danger. When evidence demonstrates a competent inspector, meaning a home inspector, should reasonably have expected to have discovered the defective conditions, the conditions are not considered concealed, and there can be no recovery for fraudulent concealment in connection with the sale of the real estate. If it was clearly visible to a good, skilled home inspector. Buyers should be aware that they are subject to sanctions if their claims are determined to be frivolous, if they are devoid of legal merit. I came across a lawsuit, the buyer who brought the suit against the seller for failure to disclose, etc., in violation of the of common law. It was so frivolous that the court awarded the seller $40,000. Wow. I had $40,000. So, tread lightly. I mean, any attorney taking on a case better be damn sure that they've got something going for them, which I did. So buyers are not obligated to conduct destructive home investigations. For example, sellers that have hidden cracked foundation walls with insulation panels, I had one of those, or covered cracked floors with carpeting, I had one of those. So how do you, they had a before picture on their listing, in the multiple listing picture, and it showed there was no carpeting, and so it showed there was like a blank floor, but didn't like zero in on the fact, so they carpeted it because there was a huge crack that went right across the, the center of the floor. So we had some good proof that there was an intentional concealment when we laid down the carpeting. Fraud claims require a higher standard of proof than a mere preponderance of the evidence. All 6 of the required elements must be established. I'm not going to go into those 6 elements that are actually in the judge's opinion that you're going to get a copy of today in her case. A buyer's broker and there's a few in the room, is in privity of contract with the buyer, and therefore can be liable for negligent misrepresentation. Contrary to the seller, who's not in privity, seller's broker who's not in privity with the buyer. Since releases are enforceable, the seller will desire them and the buyer will ask that they be deleted. They are not enforceable if they are signed under duress or fraudulent or oppressive conduct was used to obtain the release. A seller's agent owes no fiduciary duty to potential purchasers. A seller's broker is not liable for negligent misrepresentation to a buyer because the required element of privity of contract is missing. There's no contract between the listing agent and the prospective purchaser. However, the seller's broker may be liable to a buyer if they acted openly with the seller in concealing information on the seller's disclosure statement. Sellers are liable for the statements of their agents, so you can be bound by something your agent did. That's some misrepresentation that your agent did. An agent assisting a buyer can be either a buyer's agent, a sub-agent of the seller, a dual agent, or a transaction coordinator. Buyer's agents obviously owe fiduciary duties to the buyers. A dual agent can obtain a contractual waiver as to fiduciary duties, which is understandable given the potential conflicts. Now, a lot of times the clients will say, well, you know, the home inspector didn't catch this, you know, let's sue the home inspector. And I tell them, hey, look at your home inspection agreement. You can bet that there's a provision in there that if they make a mistake, they're only responsible to pay you back what you paid them for a fee. And believe it or not, that is an enforceable limitation. Caveat emptor and as-is clauses in home inspections and the seller's disclosure statement protect sellers from most buyer claims. That's what gives them the protection. However, a false or misleading statement by the sellers or their agents or concealed defects can still provide recourse for an aggrieved buyer. And I had an aggrieved buyer. I probably didn't have to redact her name. It's a public record, but I redacted her name, so can we pass these out? Sure. I'll let you pass them out. So when you get your packet, you're going to see the complaint for failure to disclose latent defect. And as in all complaints, they're factual pleadings, so we give the factual background. I'll give you the cliff version of that in a minute here. I had a count for breach of contract, but the main thrust of the case was fraud, deceit, and misrepresentation due to the seller's disclosure statement. And behind the complaint, and I'll get back to that in a minute, is a blank seller's disclosure statement form that some of you already are familiar with and probably have in your office. And then behind that was an exhibit to the complaint. I mentioned this earlier. He wrote on here, owner never occupied, sold as is. But then when they hadn't checked off all the boxes, and in particular, there's a box here for when you highlight yellow, it doesn't come out when you Xerox it, but it's the city water system, city sewer system, and there's a plumbing system up the top there. So he checked off yes instead of unknown. Oh, that's right. I put a star off to the side there.